Be ready. 5 seconds. Start. The SURFACE Act is a comprehensive law providing for all aspects relating to the subject dealt with by that legislation, and the Act provides to persons aggrieved by measures taken under the Act a remedy by way of challenging the action taken under the Act before a quasi-judicial authority, namely the Debts Recovery Tribunal WP (C) number 5957 of 2011, with a right to file a further appeal before the Debt Recovery Appellate Tribunal, making the legislation a self-contained one-stop. Certainly, as stated in its preamble, the Consumer Protection Act 1986 is an act to provide for better protection of the interests of consumers, and for that purpose to make provision for the establishment of consumer councils and other authorities for the settlement of consumers' disputes and for matters connected therewith. Stop. Section 2 (O) of the said Act WP (C) number 5957 of 2011, thus in paragraph 34 regarding the necessity of the special law relating to securitization, thus some facts which need be taken note of are that the banks and the financial institutions have heavily financed and the petitioners and other authorities oblique industries. Stop. It is also a fact that a large sum of amount remains unrecovered. Stop. Normal process of recovery of debts through courts is lengthy, and time taken is not suited for recovery of such dues. Stop. For financial assistance rendered to the industries by the financial institutions, financial liquidity is essential, failing which there is a blockade of large sums of amounts, creating circumstances which retard the economic progress, followed by a large number of other consequential ill effects. Stop. Considering all these circumstances, the Recovery of Debts Due to Banks and Financial Institutions Act was enacted in 1993, but as the figures show, it also did not bring the desired results. Stop. Though it is submitted on behalf of the petitioners that it so happened due to inaction on the part of the governments in creating debt recovery tribunals and appointing presiding officers for a long time. Stop. Even after leaving that margin, it is to be noted that things in the concerned spheres are desired to move faster. Stop. In the present day global economy, it may be difficult to stick to old and conventional methods of financing and recovery of dues. Stop. Hence, in our view, it cannot be said that a step taken towards securitization of the debts and to evolve means for faster recovery of the NPAs was not called for, or that it was superimposition of undesired law, since one legislation was already operating in the field, namely the Recovery of Debts Due to Banks and Financial Institutions Act. Stop. It is also to be noted that the idea has not erupted abruptly to resort to such a legislation. Stop. It appears that a thought was given to the problems, and Narsimham Committee was constituted which recommended for such a legislation, keeping in view the changing times and economic situation. Whereafter, yet another expert committee was constituted, then alone the impugned law was enacted. Stop. Liquidity of finances and flow of money is essential for any healthy and growth oriented economy. Stop. But certainly, what must be kept in mind is that the law should be in derogation of the rights which are guaranteed to the people under the Constitution. Stop. The procedure should also be fair, reasonable, and valid, though it may vary looking to the different situations need to be tackled and object sought to be achieved. Stop. Over.